A ruling by Allahabad High Court has sent shockwaves through the legal community and the public alike. In a decision that has left many questioning its rationale, the court has stated that while the accused's action of grabbing the 11-year-old's breast, tearing her pajama string and trying to drag her were undeniably criminal, they did not amount to an attempt to rape. They did not amount to an attempt to rape. The judge explained that proving an attempt to rape requires showing that the perpetrators went beyond the preparation stage and had a higher degree of determination to commit the crime, a threshold that, according to the court, was not met in this case. We don't intend to get you into the nitty-gritties and legalities of it all, but these are terminologies that ordinarily we would not speak. However, this becomes important because many are calling out the interpretation by this judge, including legal experts. Now, what is this case really about? The incident dates to 2021 in Kasganj, Uttar Pradesh, where an 11-year-old girl was attacked while walking with her mother. The accused, Pawan and Akash, initially faced rape charges under the POCSO Act after they allegedly lured the girl with an offer to ride on their bike. The victim's desperate screams prompted even nearby bystanders to intervene, causing the attackers to flee the scene. Initially, the charges were serious, but after the trial court summons were challenged, the High Court revised them. Instead of an attempt to rape, the accused were charged with aggravated sexual assault and assault under Section 354B of the IPC, which deals with the abuse of a woman with the intent to disrobe. The counsel for the accused men also argued that at the stage of framing charges, the trial court is not supposed to meticulously sift and weigh the evidence and material collected in the investigation. Well, Justice V. Mahendra, in fact, let me just get you earlier cases as well. Earlier cases that have been from different courts about how they have interpreted laws, which many have pointed out are not the way to have been done. This has come from Supreme Court as well as from legal experts. Justice V. Mahendra in 2021 had said that, and this was a case involving minors, the judge had gone on to say had penetration occurred, it would be rape. Then you have Justice, in 2021, there was another case where the judge had said pressing breasts of a minor girl without disrobing doesn't amount to sexual assault under POCSO. The judge later resigned from judicial services. Then you have a 2024 case where a judge made several comments criticizing adolescent sexuality, observed that female adolescents had a duty to control their sexual urges, and High Court had acquitted an accused in a POCSO case. Remember, there have also been a lot of controversial orders that have been even questioned by legal minds and legal experts themselves, even from the Allahabad courts for that matter. But joining me right now is Indra J Singh, who's a senior, a Supreme Court advocate. Thank you very much for joining us, a senior Supreme Court advocate. Thank you very much, Indira J Singh, for joining us. I'm also being joined by Rekha Aggarwal, who's a family lawyer, as well as Rizwan Siddiquee, who is an advocate. Thank you very much, both of you, for joining me. But before I come to both of you, let me very quickly go across to Indra J Singh. Do we have Indra J Singh? Do we have Indra J Singh with us? Your time at this point. Very quickly, because I'm told you're also running short of time, I want to ask you the first question. Is this a correct inference of the law? Because one, this is POCSO. Two, this is about an 11-year-old child. Three, it's just the sheer interpretation of the law that's in question. How do you see this?
It has sent shockwaves, I must say, not only with the legal community, but the entire civil society. Now, why? Because as you rightly point out, A, it was POCSO. Now, you know, the giveaway in this judgment is the fact that this 11-year-old was dragged behind a culvert. Why does a man want to do what he's doing in secrecy? Obviously, it goes beyond the stage of preparation. And I fail to understand how the judge, what evidence does the judge want of the difference between preparation and intent. Okay. Secondly, all definitions have been amended, including definition of rape in the IPC. And, POCSO always had this distinction between assault and penetrative assault. So I think one of the problems is the judge is not aware of the amendments which have been brought to the law post-Nirbhaya in 2012 and has not realized that the very definition of rape has changed. Okay, so definitely this is a judgment which needs to be taken cognizance of. But I can tell you, I see it as part of a larger backlash against the rights of women. And I find it shocking. Just a little earlier, we had this judgment from the Chhattisgarh High Court, where the judges have held that in a case where a woman died in the process of rape, after being raped. Why? Because she was married to the man. Yes, it does bring up issues of marital rape, but if you leave aside the issue of marital rape and look at the issue of death, we're entering a new era where we are seeing rape by death. Okay, and yet the judge holds that he cannot rely on the dying declaration, notwithstanding the forensic report, which shows that the woman died of renal failure. And he knew that she had renal problems. And her allegation was that he penetrated her anus. So if you can see a trend, now coming back to the Allahabad High Court very recently again granted bail to a man on the condition that the rapist marry the raped woman. It goes against decisions of the Supreme Court. It goes against all canons of justice. And there is something very strange going on in this country. I don't understand what's happening, except to tell you that there's a backlash.
No, but Ms. Indira Jaising, I mean, I know you touched upon the Chhattisgarh court, you touched upon the Allahabad court. Just sticking to this point, Supreme Court has several times raised these concerns. I mean, there's a 2021 case where there was a similar misinterpretation of POCSO. There's a 2024 case in August 2024 where Supreme Court had set aside a judgment of Calcutta High Court as well. So there have been precedents to this. And there have been series of judgments that have been poorly worded, wrongly interpreted by lower courts. And we have discussed this. This has been out in public as well. Indira Jaising, one is women's rights and women's representation, but it's also about the interpretation of law. There seems to be something appallingly wrong.
This wrong is in the mind of the judge. And by the way, don't call these lower courts. The High Court is a constitutional court. Okay, it has jurisdiction beyond that of a lower court. So something is going wrong at very high levels in the judiciary. This is what we have to take very seriously. What is it that is going wrong at these high levels of the judiciary when it comes to the issue of sexual assault, rape? They don't even understand the meaning of, what is rape. It looks like that. So you're right. It is going wrong, and despite, one of the problems is that the Supreme Court has no methodology to sanction judges of the High Court who misinterpret the law like this. And except on an appeal. Okay. Now the point is, you and I can't file an appeal against this judgment. Okay. When there is an acquittal, we cannot file an appeal. It's only perhaps the family of the victim who can file an appeal, and corrections, if any, by the Supreme Court can only be done in its appellate jurisdiction. This is one major problem. So, for example, supposing NGOs, you, me, we wanted to take the matter to court, we have certain procedural hurdles for taking these matters to court. So this is why I think, personally, that the Supreme Court should take so much cognizance of what is going wrong with the high courts, and try to correct it either through their appellate jurisdiction or advisory jurisdiction, so that this kind of trend is reversed.
Indra Jaising, a lot has been spoken about accountability or a lack of it, and it obviously gets interpreted in different contexts very differently. But in these cases, the way the laws have been interpreted, misinterpreted, so and so, do you think there needs to be an internal systemic manner of accountability, of ensuring accountability? Because not everybody has the time and the money to go to run after courts. Anyway, hearing and a system of justice takes a whole lot of time, effort, and a toll on one's whole life or whatever is left. And then to go on further with it, court to court, is not easy. How do you see this move forward?
Thank you for this question. It's a very important one. I agree with everything that you're saying. No one has the time, resources, energy. And let me tell you, there is litigation fatigue in the litigants, okay? So yes, I do believe that there should be systemic, periodic reviews of judgments of individual judges for their sensitivity, for their compliance with the law, and this kind of routine monitoring and evaluation of the content of judgments of the court should be put in place by the Supreme Court of India and be carried out regularly, so that at least they can give guidelines, and I mean guidelines which are legal in nature. I don't mean that they can tell the judge of the High Court how to write a judgment, but an approach. Like, for example, the former Chief Justice of India, Justice Chandrachud, published a gender glossary. We should have publications of this kind by the Supreme Court, which tell you what the law is, and then monitor whether they're complying with the law. I think it's a very important question that you have raised.
Lastly, for people who have been outraging, upset, angry, and even questioning what the court said, do you want to set it on record? For whatever it is, groping, opening up the pajama strings, dragging a person under, is this rape or is this not rape? I know there are so many other contours and contexts to answer a question like this, but how would you respond to this?
Yes, once again, I have to agree with you. Let's give it a legal name. It's an attempt to commit penetrative sexual assault and sexual assault. The law says it in so many words, so why are we fighting shy of it? I don't get the point. It's an 11-year-old child. What do you want? Do you want us to show you marks of resistance? Is she expected to show wounds on her body before you can expect a judgment which says this was an attempt to rape? What exactly? Let the judges clarify what they mean when they say we want intent to be proved. How do you prove intent? Intent is proved by actions which precede the actual act of rape, because the offense, remember, was not an offense of rape. It was attempt to commit rape.
Right, Indra J Singh, thank you very much for your time. Thank you for your interpretations. And most importantly, we even haven't discussed one very important aspect, and that is just the trauma of a minor or anybody to go through this whole process of justice, which possibly may sometimes not land up in the right hands of justice, may be seen as injustice. But this is in itself a huge, huge hurdle. But Indra J Singh, thank you very much for your time. Thank you very much.
Well, tell me, if children lose faith in the judiciary, where do we go from there? This is the point we're at right now.
I think that's a question that...
Yeah, loss of faith in the judiciary for the children of this country. Where do you go from there?
I just hope we don't reach that. And I'm glad people like you are raising your voice. I think that gives definitely some sense of comfort.
Thank you.
Thank you very much. Thank you very much, Ms. Indra J Singh. Well, I'm being joined by Rekha Aggarwal, who's a family lawyer, as well as Rizwan Siddiquee, who's an advocate. Thank you very much, both of you, for joining me. Rizwan Siddiquee, my very quick question. What do you make out of what the judge said and the interpretation of the law? Indira Jaising has in fact gone a step further, and she said she just doesn't know what's happening in the legal system.
See, I have a very different take to this entire episode. What happens is that the reasoning given by the judge is something that needs to be looked into. What was weighing on the judge's mind when he wrote a judgment like that? What did he consider? What did he not consider? Also the points of law, the sections and the definitions which were looked into while drafting that particular judgment. So unless and until we don't look at the entire judgment from the point where the judge is looking at from, it'll be very difficult to just criticize the judgment as an outsider, because what happens is that when the judges write a judgment, they have gone through the whole trial. They have understood the whole trial. They've understood what was there in cross-examination, what was not there, what was asked, what was not asked. We as individuals who look at the entire case from a third-party perspective, we only look at the judgment and limited parts of the judgment, and then we start to scrutinize those judgments and we come to our own interpretations. I personally feel, because as a trial lawyer, I have been doing this for almost 26 years now, and I see that the judgments may not be, capturing each and every day of trial, but nonetheless, they do bring out things which weighed on the judge's mind. And most of the times the judges also change when the trial is already midway. The judges change. There are things which have to be looked at right from the very beginning. The perspective changes. So it is very difficult. I understand the sympathy.
See,
I
judges,
understand the public
I get it.
outrage.
Rizwan
I
Siddiquee, my
understand
point
everything
is this.
as a part of the public.
Judges may change, perceptions may change. There may be other challenges that will come, sure. But how does a law get interpreted, or as legal experts are saying, misinterpreted by even judges?
I'm coming to that part.
Repeatedly.
I come to that part. Now, if you look at the portions of law, if you look at the sections, the definitions, what would amount to rape and what would not amount to rape? Like, for example, I'll give you a very common example. There could be insult to modesty, 509. There could be outraging modesty, 354, and then there could be rape. But when we invoke the section in the charges of rape, we do not invoke the other two sections. So you understand the way the law, the judiciary, the courts function are very different, and this may not be something that a common man would understand. I understand that they are only looking at it from a third-party perspective, that why is it like this, why is it like that. I'll give you a common example. There was an incident where some priest spoke about causing religious disharmony. Another man posted it on the Twitter, and the man got picked up all the way from Allahabad. There was an FIR
I just humbly request you one thing. Yeah. We are talking about sexual abuse. We are talking about rape. I don't think we need other cases right now. This itself is very complicated. So let's just stick to examples of this so that we can actually just break this down. Now, you are saying that a lay person may not understand the segments in. Before I get back to you, let me just get in Rekha Aggarwal. So essentially, Rekha Aggarwal, Rizwan Siddiquee is saying that a lay person may not understand the sections and the way the sections are interpreted. Fine, lay person may not, but you have Indra J Singh and you have legal experts who are repeatedly pointing out, look at the way how laws are being interpreted. Now, here's a very simple case. Again and again, from the courts where justice is supposed to happen, you have legal experts who are saying it's not the right interpretation.
I fully agree with you, Shreya, and whatever Ms. Indira Jaising said. It is a very shocking case, very shocking judgment passed by the Honorable Judge of the Allahabad High Court. I wonder from where he got the facts that made him pass the judgment that is under scrutiny in this show. Because the very fact that the summons were issued to the accused persons, Pawan and Akash, for attempt to rape. Now, though the sessions judge who issued the summons obviously issued the summons based upon the facts written in the charge sheet and whatever investigation, whatever taftish the police had done, and on the basis of the charge sheet, the charge of attempt to rape was made out, and that is where the summons were issued. So there was material before the trial court judge on the basis of which the summons were issued by the sessions judge. Now, what the High Court has judged in revision, modified the charges, lowered the charges, and directed the sessions court to issue fresh summons, not on attempt to rape, but on criminal assault and, attempt to disrobing the woman and under the POCSO. So obviously, there's a total misinterpretation of not only the facts, but also the law. Now, as a judge who was hearing a matter in a revision, The facts were I think the scope of the judge was very limited at this point of time in the High Court. He could not have given his own interpretation. That was a matter of trial. That would have been left best to the sessions judge to decide whether it was actually a case of attempt to rape or not. Here, the judge has modified the charges itself by saying that no charge of attempt to rape can be made out. Let's understand there's a difference between holding a person guilty of a charge and actually modifying the charge itself. Here, the charge itself has been modified. So, therefore, the accused is not going to face the trial of attempt to rape. Whereas, on the facts itself, the charge is made out.
Specific points that
Ms.
Rekha is really arguing about.
I'll respond to this. Yes. I'll clarify this part. See, whenever there is a case which has been tried at the hands of the police officer and there is a section 173 report filed which is called a charge sheet, it could be a summary, B summary or a C summary. And when these charge sheet, the investigation report which is called, is filed before the magistrate or is filed before the sessions judge or is filed before the POCSO judge, whichever judge it may be, the judges will relook into the entire thing, they will relook into the charge sheet and then they will issue summons. Now at this stage, the application of judicial mind is not to that level that they have applied their own mind. There is no trial which has started. There is no examination of witnesses, cross-examination of anybody. This is just a summons stage. What I'm talking about, when the High Court comes into power, when the High Court is exercising its extraordinary jurisdiction under Article 226, read with Section 482 of the Criminal Procedure Code, it acts as a constitutional court. And what I can make out very clearly is that the accused, which is always at a higher pedestal, accused is always placed at a higher pedestal as compared to the complainant. And that is the law which we cannot change. So when they go before the higher court, that means the highest court being the constitutional court, the High Court will have to hear the accused, what are the grievances of the accused, and what is the case that they're bringing out before the constitutional court. The High Court will not ignore or overlook that. So there is a procedure. There is a procedure that needs to be looked into.
What do you mean? What do you mean, advocate, when you say that a accused is placed at a higher pedestal than a complainant? What do you mean by that?
Okay. So this is the law that has been there for maybe 200-300 years. This is the law because the prosecution is duty bound to bring out its case. It is not the accused. The accused is always innocent till proven guilty, till proved guilty. So basically, the laws are always going to be favoring the accused and not the prosecutor, not the prosecutor and not the person who's made the complaint. So basically, prosecutor meaning the police machinery, which is getting into action, and the complainant. So this has been the law since the time it was introduced in our country, and this is exactly what the law is in other parts of the country and other parts of the world also.
This. Is
Most
this
of the
how
countries
you
follow
look
the
at the
same way.
interpretation of the law? That the accused will be at a higher pedestal than the complainant when the complainant is even the minor, it's not even at the equal pedestal?
Not at all, not at all. I do agree to some extent that yes, he is innocent, the accused is innocent until proved guilty, but definitely the accused is not at a higher pedestal.
Absolutely.
You know, it is the complainant, the prosecution has to prove its case, but definitely the prosecution is not, at a lower stage. The accused has to equally fight for his own defense. The accused has to put up his defense. It doesn't mean that the prosecution itself has to prove everything.
I'm only talking about what the Supreme Court says.
The accused has to put up a defense and prove it.
Okay, Rizwan Siddiquee, thank you very much. I believe you have to leave a little earlier. You have an appointment somewhere else. Thank you very much for joining us, Rizwan Siddiquee. Ms. Rekha, I want to ask you one more question. So to viewers who are looking at this entire debate, there's an outrage. At the end of it, what do you say? When a minor, a 11-year-old girl, I think, is groped at the breast, her pajama is snapped, and she is dragged, is there not intent to rape here, or are there grey areas? Why is it not an attempt to rape?
Exactly, Shreya. That is what I just said 2 minutes ago. That these are the facts which are coming out from the charge sheet itself. These are the facts which the prosecution has gathered. So therefore, here was not an intent only to disrobe. Intent to disrobe would have stopped if they had not if the girl had not been dragged into the culvert. If you had only the intention to disrobe a minor girl and and to tarnish her dignity, the case would have rested there. The defense would have rested over there. But here they have dragged the girl into the culvert, having tried to disrobe her, having attacked her, having groped her breasts. You haven't left it at that. I'm just reminded of a case of the Bombay High Court just very recently, about 2 years ago, where a lady High Court judge passed a judgment in a POCSO case and granted bail to accused person when he was held guilty, when he was sent behind bars for groping the breasts of a girl, and the High Court granted bail on the ground that he had not put his hand inside the clothes, but he had only groped her from on top of the clothes. So that case itself, had sent ripples the whole in the entire legal system, and there was a big outrage about it, and that judgment was set aside by the Honorable Supreme Court, that the very fact that the breasts of the girl had been groped, not inside but even on top of the clothes, that crime had been done. So in this case also that we are discussing of the Allahabad High Court, the very fact that the girl's breasts were groped, and her dignity was attacked, and on top of that, her pajamas were opened. So what do you open your pajamas for? You're not opening the pajamas, untying the pajamas of the girl just to make a spectacle of her and make her stand over there. You also dragged her into the culvert. So I think that Justice Mishra has totally ignored that particular fact which is there in the charge sheet, that the girl was dragged into the culvert. The very fact that she has been dragged, the preparation had already been made by groping her breasts, by untying her pajamas, by breaking the strict, and then by dragging into the culvert. The next step would have been that if her screams had not been heard by the passers-by, she would have been physically attacked and she would have been raped. So there was nothing left at all. I think as Ms. Indira Jaising also pointed out, that probably the honorable judge is not aware of the law, that the definition of rape has changed. Post Nirbhaya, if you will recall, there's a big outrage at that time in the Nirbhaya era in 2012. In fact, the lawyer, Mr. A.P. Singh of the accused, had argued that Nirbhaya was not raped at all.
Of rape that would have been changed. That's unacceptable, and that's where my next question comes. And I asked this to Indra Jaising as well. I want to ask you at your level as well. Here's the question. So if you have legal experts like you, like Indira Jaising and so on, saying that judges are not aware, judges don't know of the changes, that was not a right interpretation, where is accountability?
I think that accountability needs to be there, and there need to be more workshops at gender sensitization. I think that what Justice Mishra has done is
aren't there enough workshops on gender sensitization? Please correct me,
make out a
because
case
I keep hearing it from lawyers that they are having gender sensitization workshops. So isn't that enough of that?
But what are there workshops for the judges also? Are there refresher courses for the judges? They're also as human as other lawyers are, So if lawyers have to undergo refresher courses and workshops, I think the judges also, with utmost regard to the higher judiciary, they are much more senior and much more learned and, experienced than I am. So I really do not want to point any finger at them. But yes, I must say that life is a continuous process of learning. And what Justice Mishra, in his wisdom, has done, that's his wisdom. He says that the facts do not make out a case of attempt to rape. And that there's a difference between preparation and attempt. So be it. He's entitled to his views, but definitely it sends a wrong, signal in the media, in the society, that here you attack a girl, you pull her, in the mud under a culvert, and yet you get away simply because here this poor child was saved only because of her screams. Had the screams not been heard, the next step would have been she would have been raped. So where is the time difference left? There's no difference at all between preparation and attempt. Here was an attempt which was just thwarted because of the screams. So therefore, the attempt to rape is definitely made out, and it is not just a case of disrobing the girl and aggravated sexual assault under POCSO. It is much more serious and much more serious than what Justice Mishra has made it out to be.
I think these are important discourses, because discourse have one ultimate reason and one ultimate motive, and that is to ensure that what's happening is right. And if it is not, what course should it take? I think one of the reasons why we so closely focus of what's coming out of court is because that impacts people so much. And often there are also questions that really are raised about how law is interpreted by judges repeatedly. So thank you very much, Rekha Aggarwal, for joining us. Thank you very much for your time. Rizwan Siddiquee, who was with us earlier, and of course, Indira J Singh, who spoke to us exclusively. Thank you very much for your time. It's time for a very short break.
In association with Motorola Razr 50.